State of Tennessee v. Charles Blankenship.
Whenever you're ready.
May it please the court, I am Robert White, here on behalf of the appellant, Mr. Charles Blankenship. I'd like to reserve 5 minutes for rebuttal, if I may. On February 16th of 2023, Mr. Blankenship was convicted of a jury of his peers of possession of methamphetamine greater than 300 grams and possession of a weapon as a violent convicted felon. The trial court sentenced him to 40 years to serve on the methamphetamine conviction and a consecutive sentence of 12 years for the firearm conviction, for a total sentence of 52 years. Briefly, factually, members of the Monroe County Sheriff's Department appeared on the property where Mr. Blankenship resided to execute a search warrant. Upon arriving there, they saw a young man running from the area to a tree line where there were barrels, and I submit that one important potential part is that it's not clear if that property where the barrels were on the property or the adjacent property of Mr. Blankenship's. Firearm was discovered in the barrel. The methamphetamine was discovered. This individual running turned out to be Mr. Defendant or appellant Blankenship's adult son, who was known to be somewhat mentally handicapped. Mr. Blankenship was approximately 100 yards or more away from these events. He was subsequently questioned regarding the firearm and the methamphetamine that was discovered, and was quickly asked the detective, what do I have to do to make this go away? The detective, Brian Martin, made a statement that, well, we have over half a pound of meth and guns. Someone is going to have to go to jail for that. Mr. Blankenship suddenly took responsibility for both the drugs and the guns and was charged. His adult son was not charged in relation to the incident. At trial, it was discovered that one of the jurors, I believe juror number 6, Nicholas Harrell, turned out to be the son of the supervisor of 2 of the state's witnesses, including the designated witness that appeared at trial, Dalton Reinhart. Their direct supervisor in the Monroe County Sheriff's Department, not at the time of the offense, but at the time of trial.
So let's just jump right into that.
Sure.
I mean, what are the specific questions from the voir dire that you say this juror did not properly respond to? Because it looked like, I did just a quick glance at the record, and it looked like, once it was determined about the relationship and reported to the trial court, they had a hearing or discussed it on the record, and even at some point the court reporter says, I can look for the specific questions, but then I didn't see any specific questions actually identified in the record as to what this juror should have responded to and didn't, as you allege.
Thank you, and I'd like to respond specifically and then elaborate somewhat. I think the most poignant question is that Juror Harrell was asked by Mr. Blankenship's counsel at trial if anyone had any dealings with law enforcement not related to this case. And so I would submit that that's question specifically is poignant due to the fact that his own father obviously was and not just law enforcement in general, but the direct supervisor of two witnesses that are the investigative agency. And I think it's also important to...
Was it
Yes.
any dealings with law enforcement in general, or any dealings with the law enforcement that had been identified in the case?
The question, as I recall in the record, was asked if any dealings with law enforcement not related to this case.
Not related.
That was if that's not a direct quote, I believe that's very close to what is contained in the record.
Was the juror asked if he could be fair and impartial?
I believe all jurors were asked that by the court, as well as most likely both defense counsel. Right. But I think it's also important to think about the presence of this juror in light of the responses of other jurors, to know that he would have been within earshot, so to speak, of reasons that other jurors brought up. For example, there are a fellow juror and new law enforcement in this case. One juror responded, "I was arrested by one of the officers." One responded, "I used to hang out with one of the local officers."
Again, that's related to the specific officers. Those types of questions are related, or responses are related to the specific law enforcement identified in that case, are they not?
Well, yes, and I think that ties back to the parent of those individual supervisors. And
is there anything in the record that would show that he knew that his parent was not at the time of the crime, even I think on the force, but later was in a supervisory capacity to these
if the juror
people?
knew that at the time of trial? If I'm not mistaken, this particular juror was subpoenaed to testify at the motion for new trial, and it's my recollection that in that particular transcript, he acknowledges that he knew his father was the supervisor at the time.
I think if I read the state's correctly, that there was also, though, some testimony that he and his father weren't speaking. So is that a correct assessment of the record?
I don't...
Or because didn't have a whole lot of dealings with one another at the time anyway.
I think that comment or that statement, Your Honor, is more in tune with what the record actually says. I don't believe that there's anything in there to say that they were not speaking at all, but perhaps they didn't talk every day or have a particular...
So I guess the question then is, what does dealings mean? You know, how far do we have to go? I mean, if the juror's father, he may have known his father was in law enforcement, but if they're estranged and don't speak, does he have dealings with him?
Well,
or if they talk, or if he talks to his mother and she happens to say, "Hey, here's what's going on with your dad," does he really have dealings with that individual? I mean, we don't know. I get that, but where's the line on how you define dealings?
Well, I would submit that it's presumptive bias to think that you wouldn't have dealings with your own parent, who is the direct supervisor of two of the material witnesses in this case. And I think about, and I cited this case in my brief, the Romero case that cites the Tate case that says the presumption of a fair trial is just as important as the reality. And I find it troubling that the son of the supervising law enforcement officer of 2 witnesses, even though it wasn't at the time of the offense, but it's at the time of the trial. I mean, we all like to think there's not bias, but I'm sure that the supervisor of the 2 law enforcement agents that were working this case
How does that create bias?
had a stake in the outcome.
How does that create bias? I mean, his dad is the supervisor of 2 witnesses. Why does that, I mean, for all we know, his dad comes home and badmouths the 2 officers all the time as not being good. I mean, how does that create bias?
Well,
What's in it for the dad / the juror because he's the supervisor?
well, I mean, one, it's the appearance, because I think at a minimum, it establishes the presumption of bias. And then the standard, as I understand, is you look at the totality of the circumstances to see if it overcomes the presumption, and that mere self-serving statements, which I submit is what we have at the motion for a new trial. I mean, I just don't think it's plausible to think that the responses of all these other jurors, and him asked if he had dealings, that you would sit there silent if your own father, if you didn't have some bias. I mean, it just defies logic, I would submit, to think that you wouldn't say something in that
Let me ask
instance.
it this way. If the juror were asked about the relationship with his father and that were developed, and the juror then responded, in spite of that relationship, sir, can you be fair and impartial? And the judge did not excuse that juror for cause, do you think he would have an appellate issue?
Not if the defense attorney didn't. Maybe not, but you certainly give the defense a chance to exercise a challenge in that instance. And so that's what you've denied the defense in this instance, to even consider that because of the juror's silence. So I guess that's the best way I know to answer Your Honor's question.
Did defense use all of its peremptory challenges in this
I was
case?
just going to ask that.
Sorry.
Literally just wrote that down.
I cannot say whether they did or not. I do not recall from the record whether they did.
Do you know, I guess you're saying you don't know if it's even in the record,
I don't.
if we have anything in the record to show whether they were all used or not, if that came up at the motion for new trial, or?
I don't recall that being part of the motion for new trial. The motion for new trial, as I recall, was, other issues, obviously, but it's pertinent to this issue, was the testimony of Juror Harrell, and then argument as it relates to this issue. I don't recall anything in the record related to, I'm not saying it's not there.
Or if we have the challenges in the technical record, I don't know, it sounds like you're not sure either, but it'll be what it is.
I do not believe the challenges are in the appellate record. I can say that. If there's no other questions related to that issue, I would like to briefly move on to the issue 2 and issue 3 that are somewhat related, although issue 2 that I raise in my brief is the motion to suppress the voluntariness of the statement. I described briefly, factually, the scenario regarding appellate Blankenship. So, absent this statement, which I submit is not a voluntary statement, because at a minimum there is an implied promise from Detective Martin when he makes the statement, well, we've got over half a pound of meth here and a gun, somebody's got to go to jail for it. And that's in response to Mr. Blankenship making statements related to if I take ownership of this, will my son not go to jail? And so I submit that, and of course the trial court did not find Mr. Blankenship credible at his testimony related to this issue, and sided with the credibility of Detective Martin. Even so, that I submit, based on the statements of Detective Martin alone, creates an implied promise. And
I'm struggling to see how that creates an implied promise.
Well,
A promise of what? He just said, somebody's got to be responsible for this.
right, well, the whole case, and I guess this bleeds over a little bit into the next issue, but the whole case against Appellant Blankenship would be a constructive possession case, I would submit, when it goes
Well,
to
but
the...
didn't he, when he agrees to talk, and I mean, it's not like he just said, okay, yeah, they're mine, I want to protect my son. He kind of goes on and on and on with all these interesting facts about the cartel from whom he gets his drugs, and it's, if he was making that up to cover for his son, again, this goes to the trial court's credibility finding, he's a really good storyteller off the fly. So,
Well,
I mean, and to me, that's what I think the trial judge focused on as to why it said that's just not credible, because, he gave a whole lot of information, not just, okay, I agree to, it was mine, so my son doesn't get in trouble for this.
and I understand that, and that's why, I mean, there's not really the trial court gets to judge credibility issues, obviously. But if I recall the statement correctly, at the beginning of the statement, it's what do I have to do to make this go away? And that's where the colloquial between Detective Martin and the defendant happens as to, well, somebody's got to go to jail. So I would submit that's where the court should measure the voluntariness of the statement, is at the beginning, and whatever happens afterwards, regardless of how outlandish or elaborate it may be, that voluntariness threshold has already been overcome. So
You're welcome to eat into your rebuttal time and keep going, or you can wait and reserve your time for rebuttal.
I think I'm going to yield momentarily and reserve my time. Thank you.
Thank you.
May it please the court, Catherine Redding on behalf of the state. The defendant has failed to establish that juror NH's inclusion deprived him of an impartial jury. And I think in order to understand the testimony that came out about this issue, it's important to understand the timeline of when this offense occurred and what, rather than repeat NH and JH over and over, the father and the juror, understand where the father was working at the time of the offense and at the trial. So what we have is this offense occurred in November 2019. At that time, the father was working for the Madisonville Police Department. He had been working there since 2008. There's some indication in the record that he was a school resources officer when he worked for Madisonville Police Department. The trial occurred 3.5 years later, February 2023. At that time, the father was employed as the chief of detectives at the Monroe County Sheriff's Office. He had started there in July 2022, and he actually left that position at the end of March 2023. So the father was not affiliated, was not at all involved with this case at the time of the offense. He only joined Monroe County the summer before this case went to trial. And in that capacity, he supervised Detective Reinhardt, but Sergeant Martin, who had the conversations with the defendant, worked for Highway Patrol. So it's my understanding he would not have been supervising Sergeant Martin. Now, moving to the claims, the defendant can't establish a presumption of bias. So the binding case law is very clear that a relationship to a law enforcement officer on its own does not establish a presumption of bias. And the second here, the juror did not answer any questions falsely or withhold requested information. I think the court has identified this. The first question was, are you related to or do you have a relationship with anyone involved in the case? And then a whole line of people was listed, none of whom were all witnesses or actively involved in the investigation. Certainly the father was not mentioned in this line. And that question would not have prompted it even if they hadn't listed the father, because his father was not involved in the case. There was a question about whether the jurors had strongly held beliefs about law enforcement that could impact their ability to remain fair and impartial. The juror did not respond to this. I mean, it's just speculation to conclude that he did in fact have these very strong held beliefs that would affect his ability to be impartial. And the question that defense counsel focused on today was the question of whether the potential jurors had any dealings with law enforcement officers other than those listed, and his position that should have elicited the response. And I think the court's right. It comes down to how do we understand the term dealings. I mean, even the jurors that defense counsel mentioned were talking about, oh, well, I've been arrested by this person. I've had run-ins. And so the question is, do you have dealings with your parents, or do you have relationships?
Don't you think that's a fair leap, not a very big one, to say you have dealings with your parents? I mean, even if you're estranged, you still, I have dealings with my parents, right?
I think the way that a common person would understand the word dealings is it seems more transactional, or somehow it's distinct from your familial relationship. And I will point out that there's nothing in the record to indicate that the juror and his father were actually estranged. He said, I only talked to my dad once every 2 or 3 weeks. So I think they had a relationship, but they weren't close. But there really wasn't any development of that other than the juror saying, well, we didn't talk about the case. And when he was asked about his father's kind of law enforcement career, it came out that the juror really had hoped his father was going to retire when he left Madisonville, and was not, there's no indication of, yes, like, my father's in law enforcement, I believe everything that every law enforcement officer will ever tell me. And then if you get back to the question about dealings, I think, so...
Well, were there other jurors who made disclosures about their relationships and interactions with other law enforcement that were not on the specific witness list of those law enforcement officers involved in the case?
I don't remember off the top of my head. I recall defense counsel's mention of the juror who said, well, I was arrested by this person, or I've had dealings, but I don't remember anyone saying, oh, well, which you see frequently, my brother-in-law is a police officer, well, would that affect your ability to be fair and impartial? I don't recall something like that would have... I
just was curious if the questions that were asked prompted other jurors to answer to that kind of less specific information about relationships with law enforcement.
Obviously, the record will reflect exactly what occurred. I don't recall seeing something where there was a response that, for me, flagged, oh, he really should have spoken up at this point. Even if he wasn't in the box, he should have been raising his hand, or he should have, once he made it into the box, said, oh, yes, there is something that I think that you should know.
It does seem a little unusual. Don't you agree that he wouldn't have disclosed it? And frankly, it seems like most people want to disclose anything and everything they can to, unfortunately, get out of jury duty. As a trial judge, I used to try to talk them out of that mindset. But, I mean, usually it's just like, word garbage, anything I think I can say to get out of this, or to have somebody challenge me. So
Sure. And I think that, I agree that certainly does happen. But I think that it's the nature of the questions that were asked here. We often see cases where one of the attorneys will ask the reporter, is anybody related to law enforcement? And then follow up on that. But we don't have that. We have is anybody related to law enforcement involved in this case? Does anybody have any dealings or anything that would affect your ability to be fair and impartial? If you start broad, but then we narrow down, and by the time the question is actually answered, we have a very narrow question that doesn't elicit the responses. And maybe a lawyer would think, okay, well, we've got this basis here. But I think that the question that actually gets posed to the potential jurors is a lot narrower than a broad question that would elicit the response or clearly demand a response. So
when it came to light that the juror had a potential relationship with law enforcement, was that juror called in, outside the presence of the other jurors, to ask more specifically about it during that point in the trial? Because that's what normally would happen.
No, the juror was not called in, and there was my recollection is that there was no request to call the juror in.
Does it have to be?
No, I think that what happened, if I recall correctly, is that the trial court looked back. I think mentioned this, the court reporter was able to pull up the questions that were asked, and the court made a finding that no, the questions that were asked did not elicit the response he didn't fail to disclose. And then there was no follow-up on that. Even the court said, if you would like to pursue this further, we can do that later, but took up more. It wasn't until after, at the motion for new trial hearing, that we heard from the juror for the first time. And I'll just point out that when the juror did make his testimony, offer his testimony at the motion for new trial hearing, it was his testimony that he heard these questions and he didn't understand the questions to be asking for this information. And moreover, there is no evidence that the juror was actually prejudiced against the defendant, or that he was exposed to extraneous information about the case, or that he exposed other jurors to extraneous information about the case. The father was, as I mentioned, didn't work at the Monroe County Sheriff's Office at the time of the offense. He wasn't involved in the case. I believe the juror testified specifically he didn't talk to his father about the case. He didn't personally know any of the officers involved in the case, and that he did not demonstrate any bias in favor of the officers. And I think the record shows that he was not particularly enamored of his father's continued involvement in a law enforcement career. So I think that to get to where we need to go to give the defendant the relief he's requesting calls for a lot of speculation that the record just doesn't support a determination that the defendant's entitled to relief. As to the suppression issue, this court must presume that the trial court's decision to deny the motion to suppress was correct because the defendants failed to provide an adequate record. So there are two recordings. At the suppression hearing, there is a recording from the body camera that includes the entire interview from start to finish. The state moved to admit it as an exhibit at the hearing. The trial court relied on it. It's not in the record. But what we do have what we have from the suppression hearing is testimony. And it's clear that the court reviewed the video, and then we have the testimony from the officers. But we don't have that video that deals with what happened before the defendant began his long story of how he acquired all this methamphetamine and the whole tortured tale. So without that recording that shows what happened before the defendant offered his confession, where he said, this methamphetamine is mine, this court cannot conduct an appropriate review because it simply just doesn't have the recording that it needs to understand what happened. And yes, there is a recording that's entered as an exhibit at trial, but it is clearly redacted. We don't have the important back and forth. We just have the confession, and that's not enough. But if this court were to look past the absence of the full recording, the limited record that it does have supports the denial of the motion to suppress. So we have testimony from the defendant saying, I made this statement in order to get leniency for my son. I claimed this so they wouldn't charge him. But then we have Sergeant Martin, who denies threatening the defendant, denies offering to make the charges go away in exchange for the defendant setting up the Aryan Brotherhood, which is what the defendant's claim was, and he denied discussing anything that might happen to the son. And the trial court specifically accredited Sergeant Martin and discredited the defendant. So even if we go further than that, what we have, we look at the redacted interview, it supports and is consistent with Sergeant Martin's testimony. And it shows that Sergeant Martin repeatedly advised the defendant, look, I don't have the power to make this go away. I can't make you any promises. I can't guarantee that this is going to go away. And to the extent that this portion of the interview is reflective of the rest, it appears that there was a cordial conversation. And there's no behavior on the part of the state's agents that overbore the defendant's will. What this record shows is consistent with the trial court's conclusion that, yes, the defendant may have confessed to protect his son, but it wasn't the state that forced him to confess. They did not it was the defendant. The defendant might have had his own reasons for doing it, but what the reasons were from his internal decisions about what to do for himself and his family rather than what the state was forcing him to do. And that's the question. So for those reasons, unless this court has any further questions or would like to explore any of the other issues.
Yeah, so obviously the defense makes the argument on the sufficiency of the evidence that if you exclude the statement, there's no evidence, right? Sufficient to sustain it. Is there, if we were to agree with the defendant, could we sustain the verdict without the statement?
I think it would be harder, but I think that you have it's methamphetamine that's on the defendant's property. It's under, even if it's not clear what the boundary line is, but I think a reasonable jury viewing the light and the most favorable to the state could find that it was on the defendant's property. That, but you get into the knowledge of it, it's a little bit trickier, but there's testimony from the officers that this property is covered in hundreds of distinctive blue barrels that are used in chicken coops, and then the gun is found next to one and the methamphetamine is found underneath one.
Is there testimony that those blue barrels, maybe this one in question, we're not sure if it was actually on the property line? Are the other blue barrels on the property line? Is there any specific evidence to that?
I believe there are, I think there's either photo or video, but the evidence that is presented is that there's you pull up onto the property, there's a trailer and there's a barn, and then there are just barrels everywhere, and that the barrel is in the woods is consistent with the barrels next to the trailer, and it's clear that the defendant, I think he said his mother owns the property, but he's lived there for 20 years, something, for an extended period of time. But it's certainly the strongest evidence is the defendant's statement admitting that he possessed the guns and the methamphetamine. So, if there are no further questions, the state asks this court to affirm the judgment. Thank you.
Thank you, General. You should have some rebuttal time left. There you go.
Thank you. I wanted to respond first to what I'll refer to as the juror issue. And in looking back, some of the questions that was asked to the appellee, there was a juror that responded to the question that's been referenced, if anyone had any dealings with law enforcement not related to this case. And a prospective juror indicated that he and his wife were retired law enforcement. So that is one example of a response from a prospective juror not related to any law enforcement in this case. That was presumably in the presence of Juror Harrell. There's another prospective juror that disclosed that she had dealt with law enforcement often with tenants, but it would not impact her ability to be fair. So there were jurors that responded related to the dealings question in reference to relationships with law enforcement outside of the officers related to this particular case. I would submit that the testimony from, and I do believe counsel's right upon further reflection, that Juror Harrell stated that he and his father talked every few weeks. I would submit that that clearly would fall within the purview of dealings. It's kind of hard to, I would say, argue the opposite, that that's not, wouldn't elicit a response to dealings, particularly in the context of the back and forth between other jurors and how they've responded, as has been referenced. So, and I understand that, pardon me. That again, that the presumption of bias is not overcome simply by a self-serving statement that, which I submit is all we have from Juror Harrell. So I would submit that this does establish bias, and that Mr. Blankenship should be granted a new trial on that basis. In relation to the statement related to Mr. Blankenship taking ownership of the
Before we get into the actual
yes.
statement, how can we review what took place if we don't have everything that the court reviewed?
Well, it apparently from the record, the first statement, it's referenced, but I don't see in the record where it was actually ever entered as an exhibit. I also don't see, though, any indication that the recording that was entered at trial was redacted. I've looked at the record on that issue. I don't recall seeing it. I know that the court, of course, can take the record that's before it and consider all of the record, including the record at trial, in reviewing a pretrial issue such as suppression.
But if you're correct, and it wasn't admitted into evidence, we can't, at the suppression hearing, an unredacted version, we couldn't consider that now.
Well, my understanding is the court could consider the entire record related to the suppression issue. I recall the trial judge referencing that he had reviewed a recording. I don't see that it was actually entered as an exhibit. Now, whether it's a different recording that was what at trial, I don't think the record's clear.
Okay.
But respectfully, I've argued some of the issues. I rely on my brief on the other issues, and respectfully, I'd ask that Mr. Blankenship be granted a new trial, and I thank each and every one of you for your time today.
Thank you.
Thank you.
Thank you both. Case will be submitted.